The District Court of Ellis County, Kansas, case number 24 CR 64, 78, and 80. All three captioned State of Kansas versus Jason Carl Johnson. May I have an announcement of appearances, please?
May it please the court, the state appears by Aaron J. Cunningham, Assistant Ellis County Attorney in all matters via Zoom.
Morning, Your Honor. The defendant, Jason Carl Johnson, appears via Zoom from the Ellis County Jail. Mr. Johnson is represented today by court-appointed counsel, to wit, Joe Shepak, Kansas Supreme Court number 11596. I believe we're here on defense counsel's motions to withdraw.
Yes, this matter, these matters have been filed. They've gone to prelim, but I'm not showing that we've had arraignment yet. Or at least there's no journal entry from arraignment.
That is correct, Your Honor. We have not proceeded to arraignment yet.
Okay. We also have some pro se motions that have been filed. 2 motions to suppress and dismiss, July 1st of 2024, and a quote, fruit of the poisonous tree motion also on July 1st of 2024. So we're on for status on those as well. Anything else we need to take up today other than those motions?
I don't believe so, Your Honor.
Okay. Mr. Johnson, have you received a copy of Mr. Shepak's motion to withdraw?
I haven't received anything, no.
You have not received it?
No.
3 hours later.
County Jail. Do you know if he's received the motion?
Not off the top of my head, Your Honor. I'd have to check his incoming mail unless it was sent as a document service, in which case we'd be able to look up which deputy served it upon him.
It wasn't sent to be served, just a copy to him.
Yeah, I wouldn't know off the top of my head, Your Honor. If it just came in the mail, it would have been logged if it was given to him.
You have someone check his papers?
I can get on that, Your Honor.
Your Honor, while he's doing that, I do just want to note for the record, in the journal entry from the preliminary hearing back on July 1st, when we were in front of Judge Boone, we did take up the defendant's pro se motions. Mr. Shepak at that time indicated to the court that as legal counsel, he was not going to be litigating those motions and that he had no obligation to do so since Mr. Johnson was represented by counsel at that time. So those have been, in a sense, addressed. It's my understanding that they're not moving forward on those. At least Mr. Shepak was not planning to do so.
That would be a correct statement, Your Honor.
However, if Mr. Shepak withdraws, then they're still pending. There has not been a hearing on the merits on his motions.
Correct, Your Honor.
Okay.
10-4. Your Honor, we don't have anything on file as incoming or being served to Mr. Johnson.
So,
3 hours later.
Mr. Cunningham, can you send the 5 pages on the motion to withdraw up to the jail?
At this time, Your Honor?
Yeah, the defendant needs to see the motion.
Your Honor, can't the court just screen share the motion through Zoom?
I'm not sure I can make it big enough for him to read it all.
I can get a hard copy sent over, Your Honor.
If it can be emailed, we can print it.
You send a hard, I'm gonna go ahead and screen share this. And then, but if you could send him a hard copy, that would be great.
Yeah,
Can you read that, Mr. Johnson?
yeah, yes,
Okay, the top is simply your caption,
okay,
and there's one identical ones filed in all three cases.
okay.
You've been able to read that page?
Yeah, okay,
Page 2 is simply his signature.
okay,
We got page 3. That's going to be a lot harder to read. Can't make it any bigger or it comes off the page. Can you read that at all?
yeah, a little bit.
Ms. Anderson is on her way over with the hard copy.
Thank you.
Control County Attorney's Office is on the way over.
Okay.
A hard copy of this document. We need it up here. Please.
Let me know when you've read through the 5th paragraph.
I pretty much read it. I just,
The document is in front of me, Your Honor.
Okay, that's probably going to be a lot easier to read. Mr. Johnson, have you had a chance to discuss this motion with Mr. Shepak?
No, I haven't talked to him since pretty much he came with my plea until July 11th or 12th, something around
Would
there.
you like an opportunity to discuss this with him in a breakout room?
No, it's fine. I just want to get it over with, so.
Well, the question for the court is, have you and Mr. Shepak reached a point where you cannot communicate effectively with one another?
I have never had him communicate with me at all, really. I've asked him to talk to the district attorney, and I haven't got no answers back from him. I've seen him maybe 3 times in the 8 months I've been here, and talked to him twice on the phone. During my prelim, I didn't even get a chance to talk to him. He said he didn't need to talk to me about anything. I didn't have a chance to talk to him about anything. So it's, right to my point, it's, he's not communicating with me at all with my case. That's why I asked him to withdraw from him, because I don't know I've been here for 8 months, and I don't, it's been 3 months since my prelim, and I still haven't got a arraignment or anything. I mean, I don't know what's going on.
All right. Mr. Shepak, do you see any value in the two of you going into a breakout room?
No, the defendant is very fond of calling this office. Sometimes he talks to me. Most of the time he talks to my secretary. The common or recurring theme is he does not want me as his attorney. This was stated by the defendant to me on September 18, 2024 via phone call.
All right. Do you believe, Mr. Shepak, that the communication between yourself and the defendant is such that you're not able to effectively represent him at this time?
Yes, Your Honor, and put that to perspective, I oftentimes am appointed to represent people who are, how do we say, difficult or problematic clients. I've even represented Matthew Markley successfully. That said, Mr. Johnson wants to present his own unique legal theory and arguments to the court. I, of course, constrained by Kansas Rule of Professional Conduct 3.1, short title, Meritorious Claims and Contentions, looking at footnote to Rule 3.1. And I'll quote from that: what is required of lawyers, however, is that they inform themselves about the facts of their clients' cases and the applicable law and determine whether they can make good faith arguments in support of their client positions. We went through a preliminary hearing in each of these cases, Your Honor, and the facts adduced at the prelim do not support motion press, certainly in 2 of those cases, which is why I have not filed any motions to suppress. My client is not confident in my judgment, apparently, so I think it's time for a parting of the ways.
Okay. Mr. Shepak, the court will allow you to withdraw these matters.
I will prepare the appropriate order, Your Honor.
Thank you. Mr. Johnson, what'll happen now, the court needs to find another attorney who can represent you, which is not very easily done when you're looking at a level 2 drug felony. Okay. Because that's a high-level drug felony, and there's not a lot of attorneys in the bids appointment process that are qualified to represent level 2 drug felony. We will find another attorney and get them in touch with you. Need to schedule an arraignment in this matter. Once the attorney gets up to speed, we will need to schedule a status as soon as we know who the attorney is. Okay?
Okay, and I've been in contact with a couple of different attorneys that said that they would take my case, but I didn't have the money to do it on a couple of them. And then Alex Herman came up and talked to me also, and he said he'd be willing to take my case also.
Well, if you have the means to hire an attorney, that's fine. You certainly are welcome to hire an attorney at any time you wish to. But you have applied for a court-appointed counsel. Court has found that you qualify for court-appointed counsel, and the court will appoint counsel, but in the appointed counsel, you don't pick your attorney. Clerk working with bids picks the attorney based on the attorneys who qualify to do a level 2 drug felony. Okay?
Yeah.
So we'll figure out which attorney is going to be appointed, get them in touch.
Okay, and I also I've had Cheryl Stewart before that I don't trust her either. I mean, she lied to me and about stuff that was going on in my case previously to that, so that wouldn't be a good match either. If that's one of the options. I don't know if I could put that in the order or not.
Well, again, the clerk will check and see who qualifies, who the next attorney is who qualifies to do a level 2 drug felony.
All right.
And then we'll need to set this for a status and find out how long it's going to take that attorney to get up to speed on your case so we can move forward with arraignment and get this rolling.
All right.
Okay?
Yeah.
Do you have any questions?
No.
Okay. Mr. Shepak will do his orders to withdraw. Mr. Cunningham, you'll need to do an order scheduling a status as soon as we know who's appointed.
Yes, Your Honor.
Okay? Anything else today?
Not from the state.
Mr. Johnson?
No.
Okay. Thank you all.
Thank you, Your Honor.